Amendment number 9, printed in House Report 112-283. For what purpose does the gentleman from Rhode Island seek recognition? Clerk will designate the amendment.
Amendment number 9, printed in House Report number 112-283, offered by Mr. Cicilline of Rhode Island.
Pursuant to House Resolution 463, the gentleman from Rhode Island, Mr. Cicilline, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Rhode Island.
As a founding member of the bipartisan Mayors Against Illegal Guns, co-chaired by Mayor Menino of Boston and Mayor Bloomberg of New York, I rise today in strong opposition to the National Right to Carry Reciprocity Act. This dangerous legislation threatens public safety by undermining the ability of states and localities to reduce gun violence by limiting the carrying of loaded, concealed weapons within their borders. This bill has nothing to do with honoring the Second Amendment, but instead completely dishonors the rights of local communities and state governments to make decisions to protect the well-being and safety of their citizens. This bill prevents states from responding to the unique needs of their communities as they determine the eligibility criteria for carrying a loaded, concealed weapon, and instead forces them to accept standards set in other states. As a result, this bill strips away reasonable limitations properly enacted by states and imposes upon every state except Illinois the least restrictive standard in the country for carrying a concealed, loaded gun. The implications of this bill are drastic and a radical departure from well-settled practice and law that assigns primary responsibility for public safety to states and localities. In Rhode Island and in many states like it, this bill would decimate the strong concealed carry framework developed by duly elected officials within the state. These officials enacted requirements that they believe most effectively prevent dangerous individuals from carrying a concealed firearm within their borders. Rhode Island does not have any reciprocity agreements recognizing any other state permits, and our heightened standards require applicants to be at least 21 years old, of good character, not an abuser of alcohol, to complete a firearms safety training course that includes live fire examination, and to show good cause for needing a concealed carry permit. To further provide for our unique public safety needs, Rhode Island also grants broad discretion to local law enforcement officials in the process of approving or denying a concealed carry permit. As a result, Rhode Island ranks among the states with the lowest gun death rates, less than half the national average. Under this bill, Rhode Island will be forced to recognize concealed carry permits from all states, regardless of how lax the other states' standards. This would leave my fellow Rhode Islanders subject to the whims of other states' concealed carry permits, and actually prioritize the rights of out-of-state concealed carry permit holders over the rights of Rhode Islanders within our own borders. For example, while Rhode Island requires safety training that includes a live fire exam in order to acquire a concealed carry permit, there are 10 states that have no training requirements whatsoever. While Rhode Island prevents alcohol abusers from obtaining these permits, only 28 states have such a standard in place. The common sense provisions of Rhode Island state law and the laws of similarly situated states prevent dangerous individuals from carrying loaded, concealed weapons. Such protections would be completely undermined by this law. This bill is a clear and undeniable threat to public safety and will facilitate a new path that allows more and potentially dangerous individuals to carry concealed loaded guns within our borders and against our will. This must not be allowed. Because this bill presents such an indisputable threat to public safety in many states, I've introduced this amendment, which would require that at the very least, prior to granting reciprocity in a state, the Attorney General, the head of the state police, and the Secretary of State jointly certify that the laws of a non-resident permit holder state are substantially similar to its own. This would provide states an opportunity to preserve adherence to its core requirements that restrict concealed carrying weapons, but not allow them to deny permits from states that match its standards. It would at a minimum ensure that we respect the decisions and judgments made by local and state governments on this key public safety issue. The certification process will not be burdensome to states. In fact, some states, including South Dakota and Nebraska, already incorporate this type of process in determining eligibility for engaging in reciprocity agreements with other states. I urge my colleagues to support my amendment and protect the citizens of this country from the imposition of dangerously lax standards for the carrying of concealed weapons in direct contradiction to the decision of local and state governments charged with protecting the lives and safety of their citizens. I reserve the balance of my time.
Gentleman reserves the balance of his time. For what purpose the gentleman from Texas rise?
Mr. Chairman, I oppose the amendment.
Gentleman is recognized for 5 minutes.
Mr. Chairman, this is one of 3 amendments under consideration today that would allow the states to opt out of the nationwide concealed carry system that H.R. 822 seeks to establish. This undermines the bill's goal of creating national uniformity in our concealed carry laws. This amendment provides that every state attorney general, head of police, and secretary of state must certify that the concealed carry eligibility laws of every other state are substantially similar to their own before the state can participate in this legislation's grant of reciprocity. This is obviously intended to be overly burdensome both to those with concealed carry permits and to the states themselves. It is also simply a way for state officials who do not support the Second Amendment right to bear arms to decide that their state will not recognize out-of-state concealed carry permits. The amendment also incorrectly assumes that there are critical differences between the state's eligibility requirements, which is simply not the case. Each state has a vested interest in making sure that those with a propensity towards violence are not granted a concealed carry permit. Every state conducts a thorough background check so that unqualified individuals will not be able to carry a concealed firearm. The eligibility standards used by the states are more similar than not. The fact that there may be small differences among the state's eligibility laws should not allow a state to prohibit the exercise of Second Amendment rights within its boundaries. Also, federal and state laws governing the purchase of a firearm must be complied with before a person can even apply for a concealed carry permit. In order to purchase a firearm or take advantage of the reciprocity extended by H.R. 822, a person convicted of a felony or a domestic violence misdemeanor cannot legally purchase a firearm under federal law. A person must also be cleared through the Federal Bureau of Investigation's National Instant Criminal Background Check System, or NICS, before they can purchase a firearm. Data from the FBI's annual Uniform Crime Report shows that right-to-carry states, those that widely allow concealed carry permits, have 22% lower total violent crime rates, 30% lower murder rates, 46% lower robbery rates, and 12% lower aggravated assault rates as compared to the rest of the country. This amendment allows the current patchwork of concealed carry laws to continue and ignores the right to bear arms guaranteed by the Second Amendment. For those reasons, I oppose this amendment, and I'll reserve the balance of my time.
Gentleman reserves the balance of his time. Gentleman has 30 seconds remaining.
Just very quickly, the purpose is not, of course, to overly burden state governments, but instead to respect the judgments and decisions they've made in weighing the equities and making determinations as to what is the right criteria, to give respect to the duly elected officials in states who have made those judgments. It happens in South Dakota, it happens in Nebraska. It's not unduly burdensome. It's really about respecting the people in state government and in local governments who have the responsibility to protect the public health, safety, and well-being of residents of states, and I yield back the balance of my time.
Gentleman yields back the balance of his time. Gentleman from Texas.
Mr. Chairman, if you respect and support the full right of individuals to enjoy the rights under the Second Amendment to the Constitution to bear arms, you will oppose this amendment. I'll yield back the balance.
Gentleman yields back the balance of his time. The question is on the amendment offered by the gentleman from Rhode Island. Those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it.
For a
According to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Rhode Island will be postponed.